I think the ayes have it. The ayes have it.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Sarah Orley.
Thank you very much, Madam Deputy Speaker. I'm grateful to Mr Speaker for granting my request for a debate on the cost of court transcripts. Justice should not have a price tag. On that, I think we would all agree. And yet, currently, many victims are being denied access to justice because they cannot afford to pay thousands of pounds to obtain court transcripts. These extortionate costs are not only unaffordable, they are a major barrier to victims' recovery. This issue was first brought to my attention in August of this year when my constituent, Juliana Terlizzi, approached my office for assistance in obtaining a court transcript. In 2020, Juliana was drugged and then raped in her sleep by her former partner. She was then forced to wait 2 years for her case to be heard in court. Backlogs and chaos in the court system pushed back the date time and time again. Meanwhile, her attacker was free to walk the streets and use dating apps to search for other women. In January 2022, Juliana's attacker was finally convicted, but she can barely remember what was said in the courtroom due to trauma and emotional distress. Following the trial, Juliana was advised by a therapist to apply for a transcript of the proceedings to aid her healing. This transcript would enable her to revisit and process what was said in court. Juliana made an application to the court for a free copy of the transcript. Her application was rejected. She was told to contact one of the private companies outsourced by the government to supply transcripts. Upon doing so, she was quoted an astonishing £7,500. £7,500 to read what happened in a trial in which Juliana herself was the victim. £7,500 to revisit what was said while her trauma was discussed by strangers in a courtroom. This cost simply does not stack up. How can it be so high? And why must Juliana foot the bill? My team and I began to research this issue some more. I soon discovered that Juliana's extortionate quote is not an isolated case. Some victims are facing fees of up to £22,000. How can anyone be expected to pay such a fee? Court transcripts should not be a luxury that only those very few victims with thousands to spare can afford. The reason that transcripts are so important is that they are often the only means available to victims to establish exactly what happened during a trial. Victims and bereaved families do not routinely attend trial. Some choose not to avoid reliving their trauma. One victim told me that she would have been forced to sit with her abuser's friends and family in the gallery if she were present at the sentencing hearing. Others are misadvised by the police and court staff on their right to attend trial. Shockingly, some victims are actively discouraged from attending and told that their presence would be a distraction to the jury. And although the technology exists, victims are often not offered a video link to watch the trial remotely. There's a major lack of transparency of justice and a lack of information provided to victims. Most victims will only find out the verdict by a phone call. And if the outcome is not favourable, what then? How can a victim even begin to come to terms with the verdict when they have no means of understanding how it was reached? Even for those victims, like Juliana, who are able to attend trial, a combination of trauma and legal jargon mean that it is extremely difficult to recall what was said. Transcripts are therefore a vital source of information for victims and bereaved families. Transcripts can support their understanding and allow them to take steps towards recovery. The UK justice system is failing victims. Victims feel like bystanders to justice. They have no contact with the prosecution, no insight into proceedings, and very limited information on their rights as a victim. Victims have told me that their experience in the UK justice system was re-traumatising. One even described it as more traumatising than the crime committed against her. Our justice system must work to support victims, to encourage them to come forward. Without victims bravely reporting crime, there can be no justice. And yet there are currently so many disincentives to reporting a crime. Our courts are still plagued by backlogs and delays. Victims face average delays of 679 days between a crime being committed and cases concluding at court. Justice delayed is justice denied, and it allows criminals to continue walking the streets for far too long. The Conservative government's failure to get to grips with the backlog is letting down victims and their families, witnesses and also defendants, and it undermines public confidence in the justice system. And even when crimes are reported, in many cases the outcome is not favourable. According to Rape Crisis, just 2% of rapes recorded by police between July 2022 and June 2023 resulted in someone being charged that same year, let alone convicted. And for those victims that do finally see their case brought to court, once the verdict is reached, they're tossed aside. Things have to change. The Victims Commissioner for London has been working tirelessly to shine a light on the experiences of victims in the UK justice system. I met with the Commissioner to discuss the urgent reforms needed to better support victims, and I am proud to support her campaign for greater transparency in our justice system. The House of Commons Justice Select Committee has also looked into the issue of court transcript costs. In 3 separate reports over the last 18 months, the committee has recommended the government take steps to improve access to court transcripts and to reduce costs. The Scottish Criminal Justice Committee has also completed an inquiry into transcription fees, and a successful campaign led by rape survivors has secured a commitment from the Scottish Government to set up a pilot scheme to waive court transcript fees for victims of sexual violence. Yet ministers in Westminster continue to sit on their hands and allow private companies to pass extortionate costs onto victims. The Victims' Bill presents the perfect opportunity to address this gross injustice. Today, I have published an open letter to the Justice Secretary calling on the government to make provision within the Victims' Bill to enable victims and bereaved families to request a court transcript free of charge. I'm delighted to be supported by 40 co-signatories. These include members from 6 different parties across the House, amongst whom are the mother and father of the House and the chair of the Justice Select Committee. I'm also joined by the Victims Commissioner for London and senior figures from the charities Refuge, Rape Crisis, Women's Aid and Support After Murder and Manslaughter. We stand united in supporting victims and their right to access justice. The government often pays lip service to the importance of transparency and accessibility of justice. In response to a written question I tabled in September, the Minister wrote, "Accessing transcripts from proceedings in serious criminal cases is not only a fundamental right of victims, but is also essential for maintaining transparency and accountability within the justice system." I welcome this statement from the Minister, and I wholeheartedly agree with his position. So why are the government refusing to take steps that ensure that victims are able to access timely and accurate transcripts free of charge? The Minister will point to the mechanisms already in place to enable some victims and their families to obtain transcripts, such as permitting sentencing remarks to be made available at the judge's discretion, or measures to provide families bereaved by homicide but with sentencing remarks. But this is not enough. There are still countless victims who are unable to afford a transcript, and as proven in cases such as Juliana's, more often than not, victims will be told by the judge that their case does not meet the very narrow criteria for a free transcript. The government has said that providing transcripts to victims free of charge would result in a significant cost, but I do not believe that to be necessarily the case. There are steps the government could and should be taking to reduce costs. In a report on open justice published last year, the Justice Select Committee recommended that His Majesty's Courts and Tribunals Service should explore whether greater use of technology, such as AI-powered transcription, could reduce the cost of producing court transcripts. I would be grateful if the Minister were able to provide an update on whether this recommendation has been acted on. Additionally, will the government look to assess the value for money of contracts it holds with private transcription services? Are victims really getting the best possible deal? Is £7,500 a fair price to pay? I wrote to the Minister on the 15th of September to set out proposals to provide an audio recording to victims upon request. It should be possible to provide this at low or no cost, as recordings are already made of Crown Court proceedings. 2 days ago, I received a response from the Minister which said that his officials would give this matter careful consideration. I look forward to hearing more when some progress has been made. The government cannot ignore victims any longer. Victims and bereaved families need access to full, accurate transcripts of court proceedings. Anything less will be an injustice. I've tabled an amendment to the Victims Bill which would enable victims to request a transcript of court proceedings free of charge. I urge the government to accept this amendment, to finally show victims that they matter, that they did the right thing in coming forward, and that the UK justice system will support them during the trial and afterwards. Ahead of the report stage of the Victims Bill, I asked the Minister to meet with me to discuss my amendment and the experience of my constituent. His engagement on this issue is vital if this bill is to succeed in delivering a positive outcome for victims. I'd like to finish by thanking the victims, advocates and charities that have taken the time to share their experiences and insight with me. Without their tireless campaigning, change could never occur. And I now hope that the government will honour their work and commit to improving transparency and accessibility of justice for victims. And for that, victims need access to full transcripts free of charge. Thank you.
Minister Mike Freer.
Thank you, Madam Deputy Speaker. And first of all, I congratulate the Honourable Member for Richmond Park on securing this important debate. The principle that justice must be open and transparent does go to the very heart of our justice system, and upholding this principle is paramount to securing the trust and confidence of the victims, whose experiences are central to the way our society thinks and responds to crime. We are of like minds on that. And I'm sorry to hear of the experiences of the Honourable Lady's constituent, Ms Juliana Terlizzi, as she sought to obtain a trial transcript as a victim of a horrific crime. And I do recognise that there may be many reasons why victims may find a court transcript helpful in the aftermath of a lengthy and sometimes complex criminal court proceeding. In cases where victims do not attend the trial, they may seek to understand the verdict and how it was reached. Even in cases where a victim attends the trial, there are a myriad of factors which may exacerbate the difficulties that they are already experiencing in following court proceedings. This may include, for example, having to face the defendant and the defendant's family, and it may also be particularly difficult for those victims whose first language isn't English. So the ability to access transcripts from court proceedings is an essential part of maintaining transparency and accountability within the system. That is why we have provided the required technology to the Crown Courts to enable transcription of different parts of the hearing from the recording made in all proceedings. Now, there is understandably a cost attached to transcribing what could be weeks' worth of audio, and this will, of course, vary depending on the length of the trial. Transcription companies calculate the costs on a case-by-case basis, depending on a variety of factors, such as the size of the transcript, whether it is a copy being requested or a new version, and how quickly the transcript is required. Preparing a court transcript is currently a manual process whereby transcription companies listen to the audio files to transcribe the hearings. And although AI technology is available, the most recent pilots to test voice-to-text technology do not demonstrate sufficient accuracy, an element that is crucial where criminal trial records are concerned. Taken together, producing a full trial transcript, depending on its size, can cost in the region of thousands of pounds, as the Honourable Lady has quite rightly pointed out. And I do appreciate the concerns around the charges quoted for trial transcripts. However, the call to provide these to victims free of charge in all cases involves significant financial implications to the taxpayer, which does require careful analysis. It is also important to recognise that subsidising the cost of full trial transcripts using public funds risks diverting those resources away from other avenues to improve victims' services and outcomes. The Ministry of Justice has been working to make court records, such as transcripts, judgments and judicial sentencing remarks, increasingly more accessible, including more of them being published online. And I can reassure the Honourable Member that we are carefully considering these issues she raises as part of that work. And we are committed to ensuring that victims are supported at every juncture of the criminal justice system. And that is why we are taking forward the Victims and Prisoners Bill, which continues its passage through Parliament. The bill enshrines in primary legislation the overarching principles which must be reflected in the Victims' Code. These include entitlements for victims to be provided with information about the criminal justice process, as well as access to support services. This package builds on concrete measures that are already making a real difference, including our commitments in the end-to-end rate review, which has already seen us return adult rape cases reaching court to 2016 levels, well ahead of schedule. And if I may, Madam Deputy Speaker, just gently point out that it isn't true that this government has abandoned victims. This government has introduced measures that allow complainants to pre-record their evidence, saving them from having to face their attacker. We stood up 24/7 rape support line. Victims have the right to court familiarisation visits to seek a redetermination in the event that the CPS decides to reduce the charge and to make a victim personal statement. We will quadruple victim funding by 24-25, up from 41 million in 2009-2010. And we've rolled out over 800 independent sexual violence advisors. We've rolled out enhanced support at 3 Crown Courts in Newcastle, Leeds and Snaresbrook through the Specialist Sexual Violence Support Project. We've upgraded technology and facilities and will continue trauma-informed training for staff, a case coordinator to improve case progress and to give more victims more opportunity to observe sentencing hearings remotely. So I do accept, I'm going to just finish one point and happily take an intervention. So there is obviously more to be done. But I did want to gently put on record that the idea that victims of sexual crime are being abandoned is simply not true.
That point. I don't think I ever accused the government of having abandoned victims, so it's slightly odd that he's rebutting that. However, if we could just ask him to expand slightly on the request that I made about oral recordings that have been made, whether those could be provided directly to victims, so that instead of having to pay for an expensive transcript that's been created from the recording, they could just have the recording directly.
Madam Speaker, my understanding is at present it is possible for victims to visit the court by arrangement to listen to a full audio transcript of the trial. And also, my understanding is that particularly the sentencing remarks can be particularly helpful to victims understanding how, if you like, how the judgment was arrived at. And so access to those is a piece of work which we are working on at pace. So I accept the point of audio, and I'm more than happy to take away whether they can be provided as a step further than just the victim having to attend court. That's a fair challenge, which I am very happy to take away. The Honourable Lady did comment about the various reports by the Justice Select Committee, and she will also know that the Department has recently conducted a call for evidence on the matter of open justice and asked the public which court records should be published online and made available on request. And that exercise is fundamental to ensure that we continue to uphold the principles of openness and transparency whilst looking at ways to modernise the courts to meet the expectations of people. Now, the call for evidence has closed. It closed in September, and we're currently evaluating that information provided, and we will report back on our response early next year. So, alongside the Victims and Prisoners Bill and the call for evidence, I would like to assure the Honourable Lady that the Ministry of Justice is working with His Majesty's Courts and Tribunal Service to identify further opportunities to improve victims' experiences of the criminal justice system. And this includes examining, amongst other matters, the costs they incur when obtaining court transcripts. And of course, recognising that the Honourable Lady, I believe, has tabled an amendment to the bill, and she'll be able to further expand her arguments and take that up directly with the relevant Bill Minister when it comes to that specific part of the bill. So I did want to reiterate that the victims can apply to the court for permission to listen to the audio recording, to hear at a suitable location, free of charge. It is at judicial discretion, but that is an opportunity for victims to hear the trial. And to help with court transcript costs, we have made sure that bereaved family members of victims of homicide and death by dangerous driving can get a copy of the judicial sentencing remarks, a specific part of the sentencing hearings. That is paid for by the public purse, and in certain serious criminal cases, a copy of the sentencing remarks can be made. But I do accept that the Honourable Lady would like us to go further, as I've said, the call for evidence on openness is currently being evaluated, and I will ensure that her views are taken into account as part of that call for evidence. Madam Deputy Speaker, if I may, to conclude, in line with key principles of open and transparent justice, I recognise how important it is for victims to be able to access the transcript of criminal proceedings. There are existing policies that already operate to achieve transparency for victims within the criminal justice system, but I recognise that there remains concerns about the transcription charges, and I assure you, Madam Deputy Speaker, and the Honourable Lady that the Government is committed to improving the experience and support victims that they receive. The Ministry of Justice will continue to progress the Victims and Prisoners Bill to put victims' interests firmly at the heart of the justice system. We will also analyse and use the responses, as I've said, that we've received in the recent call for evidence on the matter of open justice and court records to better inform future policy. Lastly, we'll continue to identify opportunities to improve victims' experiences of the criminal justice system, which includes, to give that commitment, includes examining the charges they incur when obtaining court transcripts. Thank you, Madam.